were given this topic, Greg and I sort of put our heads together and figured out what could we tell a room full of experts on this they haven't already heard before, other than to start with the statute, read the statute again, and then before you file your suit or before you go into court, read the statute again, because that's sort of the starting point and the ending point for how the Hawaii Supreme Court in particular pays attention or treats issues of administrative law and sort of the related topics. Now, Greg and I have a background here because land use and land use issues are so tied into the administrative process at the county level and at the state level. So we did, in your materials, there's really 3 big sections in your written materials, and for those of, we are recording this for people who aren't here. These materials are posted on the website at inversecondemnation.com, so if you don't have them or if we ran out of copies, you can grab an extra one there. But the first part is simply essentially the Bible for administrative appeals, which is HRS Section 91-14 under our Administrative Procedures Act. That's the start point, the end point, and everything in between. And the Supreme Court, when it considered these issues, is essentially filling in areas left unclear by the statute. But it is the statute that guides the courts. The second part is devoted to some summaries of some recent cases of interest in no particular order, other than that was the order that we felt that they were interesting in. And then finally, just as a throwaway here, since you guys are all appellate lawyers, Section 3 is, there's 2 recent cases from the Supreme Court on appellate procedure that just are of interest. They have nothing to do with administrative law, but there's something that I think people who do civil appeals in particular should pay attention to about when's a collateral order final, and then when do you have to trigger, what is the trigger for an appeal when you have a deemed denied type situation, or an order is deemed granted or denied by operation of law. But we want to start with the language of the statute, and we've highlighted in Section 91-14 what we think are sort of the key phrases that end up being interpreted and talked about and are the focus points for courts when they look at these type of issues. Of course, the person aggrieved by a final decision in order, so person aggrieved, final decision in order, contested case, the fact that a person aggrieved includes an agency, your time limits in Part B of 30 days, so it's a very short either statute of limitations or a statute of repose, depending on how you might characterize it. But if you have to go under these provisions, you've got a very short time window to do so. And you'll see this play out not only in the cases themselves, but in the strategy that the parties take, particularly on the government side, when looking at what happened to a party that took one avenue or took another. Of course, the alternative to administrative procedures is what? Usually an original jurisdiction action in circuit court, right? Under either probably the declaratory judgment statute is where you'll see it for many parts. And then finally, the fact that a review by the appropriate court under 91-14F is confined to the record as developed by the agency, and that what powers does a circuit court have under G? It can affirm, remand, it can reverse or modify, and here's the key language that I think sometimes gets overlooked: if the substantial rights of the petitioners may have been prejudiced. So it's not if the court got it wrong or something. There has to be a finding that the substantial right of the petitioners have been impacted in one of the 5 ways that we're familiar with under 91-14G. So as we launch into the discussion, and I'm going to turn it over to Greg here, please keep those phrases in mind, because you'll see them constantly coming up, especially in the Hawaii Supreme Court, as it walks through its analysis. And if there's one thing that I think we as lawyers forget, because we like to, instead of seeing sort of the big picture sometimes, we delve right into the trees and we get right into the argument and we start citing cases and whatnot. But this is a statutory cause of action. And I forget it all the time, because in this case the Supreme Court held this, or in that case the ICA held that. But ultimately, and you'll see the Supreme Court doing this in its opinions, because they do not have a 35-page limit like we do, they will start with the text of the statute. And so even though your brief may not contain, well, here's the entire statute, your analysis in your head at least should do that. And with that, I'm going to turn it over to Greg, who will start us off.
Yeah, so I guess the first thing I thought about talking about, and it comes up a lot in land use and maybe also in other areas, but are the doctrines that force you to go through the administrative appeal process to begin with and preclude you from running straight to court. And those are the two doctrines. The Hawaii Supreme Court described them in the Kona Old Hawaiian Trails case, which I think was from the late 80s, early 90s. But those are exhaustion of remedies and primary jurisdiction. The court kind of lumped them together in explaining them. But what they are, exhaustion of administrative remedies means that if you have administrative remedies available to you, you have to go through those procedures and those steps before you can get to court. And you can't file in court at the outset. The related notion is primary jurisdiction, which exists when both a specialized administrative agency and a court have original jurisdiction over a matter. But similar to exhaustion, the courts say that they will withhold exercising jurisdiction to allow the parties to proceed through the administrative process first. So that was the Kona Old Hawaiian Trails case, which was an appeal from a special, or was not an appeal from a special management area permit issued on the Big Island, and it was filed in court as a declaratory judgment action, and the Hawaii Supreme Court said, well, the specific charter language on the Big Island says that anybody who's aggrieved by an act of the planning department can appeal that through the Board of Appeals and so on. And because the parties didn't do it, their case was dismissed. The flip side of that, to show you the other side, is again, it's another Hawaii Supreme Court case, Hawaii's Thousand Friends, which dealt with the failure of the city and county of Honolulu to obtain a special management area for the demolition of, I think it was Camp Kailua over at Kailua Beach Park years ago. That was brought as a declaratory judgment action, and the city was arguing in that case that there should have been, the original lawsuit should be dismissed. The court didn't have jurisdiction because somebody should have filed an appeal through the agency system. And the court looked at that and said there was no administrative process. So in the city and county of Honolulu, under our charter, at the time, the Zoning Board of Appeals had jurisdiction over decisions on the zoning code and the subdivision code by the city, but not over decisions under the Coastal Zone Management Act, or the SMA law. And so they said you didn't have an administrative process available, so you can go straight to court. Now, there's been two recent cases that kind of emphasize the dichotomy about this, and both of them involve what are called private rights of action, or the court recognizing that there's a private right of action to enforce something, and that is the Ala Loop case, the Hawaii Supreme Court decision from a few years ago, and also the Pavsek versus Sandvold case, which was ours at the Intermediate Court of Appeals. In both of those cases, the courts, the Supreme Court on the one hand, the ICA on the other, said that there were a private right, citizens have the private right to enforce certain land use or zoning laws. In the case of Ala Loop, it was Chapter 205. In the case of Pavsek, it was the land use ordinance, the city zoning ordinance. But both of those cases recognize that even though a citizen can sue to enforce these land use laws, the doctrines, primary jurisdiction or exhaustion remedies, still apply. And so you still have to, it doesn't mean you can file a lawsuit in court, it means you still have to go through your administrative process first. I think, I wanted to set that background because those are the things that keep you out of court to begin with and force you into this administrative process. Do you want to talk about contested case hearings? Or
Sure, I'll start us off. I mean, here's a question to throw out. What's a contested case? Anybody?
What you have to do before you appeal.
Right. I mean that's the conservative answer, right? That's what you have to have before you can institute jurisdiction in circuit court under 9114. You have to have it's appeals only from a contested case. But let's go back and maybe deconstruct that a little bit. Agencies can have hearings, right? What kind of hearings? I mean, this is a flashback to admin law. What kind of agencies are what? They're they're sort of these hybrid organizations, generally within the executive department, although here in Hawaii they're given sort of separate. They're almost the fourth branch, right? Even though they're not elected, they're appointed and then confirmed and whatnot by various, there's some boards or agencies where each part of government gets an appointment power and confirmation power. But they're either, they're quasi-legislative, which means they sort of have legislative-type rule-making functions, policy-making functions, and then, of course, they have adjudicative or quasi-adjudicative, quasi-judicial type powers, right, to hear specific cases, make factual findings, and end up with legal conclusions, usually in the permitting type of situation is where you see the quasi-judicial or sort of true administrative law proceedings. So, the short answer to my question is agency hearing. A contested case is an agency hearing that's not a policy-making type decision, not a legislative hearing. Or is it? And that's really what we get back to. And the first case in your materials is one actually from, just what date was it?
December 13th.
Just recently. I don't know if this spurred Bethany thinking about this topic, but it seems to me that here, at least among practitioners, we have a less clear conception about what a contested case is, because that's the trigger, remember, to get you into court under 9114, than the Supreme Court does. And if you're questioning what it was, the Supreme Court has repeatedly reminded us that it's not all that complex, because here we are trying to figure out, is that agency hearing a contested case, and do I have 30 days to appeal, or do I have 2 or 6 years to appeal, depending on what the statute of limitations might be for say a declaratory judgment, an original jurisdiction declaratory judgment. And those are the kind of issues that keep lawyers up late at night, right? Do I have, do I have 30 days to file an appeal, or do I have 2 plus or 6 years, right? And so the Supreme Court, if you've been paying attention, has repeatedly told us it's not that hard to figure out what a contested case is, and here's the rule of thumb, at least as I've figured it out. They're almost all contested cases. Almost everything an agency does is going to be deemed a contested case, even when it's not a contested case. And that's sort of a screwy answer, but it really is, because the Supreme Court has held if an agency hearing is required by law, and by law we mean a rule, a statute, or even a constitutional due process, because property is at issue. And of course, under both the Hawaii Supreme Court's formulation and the U.S. Supreme Court, you have, even if your own rules or statutes don't require a hearing in particular matters, due process may require you to have a hearing, or at least give notice and some kind of opportunity to be heard, if not a hearing. If any of those 3 situations kick in and there is a hearing, I don't care if it's not conducted under 9114, if it doesn't look like a quasi-trial like the contested cases that we're used to, it's going to be deemed a contested case with respect to Chapter 9114 jurisdiction issues. So it will trigger. So for example, we've got a case up now on cert to the Hawaii Supreme Court that was it's a tertiary appeal, I guess now, but it started off in circuit court under 9114, and it's challenging the Planning Commission of Kauai's denial of certain zoning permits. Now, we did not have a formal contested case. It was the Planning Commission held an open meeting type thing. All the commissioners were there. The 3 people were allocated their 3 minutes to testify. They did. It dragged on for days, as many of these things do. And at the end of it, the commission met, had a meeting, and decided to not issue the permits, after which we went to court under 9114. And the question kind of arose, that doesn't really look like a contested case, is it? Short answer, yes, because it had a hearing as required by law. Their own rules said you have to have a hearing before issuing the permit. They weren't making policy, they were making or applying policy with respect to a particular individual. And in that case, there was no question we had jurisdiction under 9114, even though it didn't look like a trial, right? Because that's sort of the paradigmatic contested case, is when you have a trial-like situation with cross-examination. And what I think is the most important part of or the most important facet of a true contested case, what I call true contested case, is the prohibition against ex parte contacts, right, with the commissioners or whoever's making the decision. Generally speaking, the hallmark of quasi-judicial type decision-making is that, right? The prohibition against ex parte contact. I can't go and see them. Yet if my city council is having a meeting in which, for instance, here in the city and county of Honolulu, it's the city council that issues shoreline permits. Other counties, it's planning commissions for the most part, I think. But here, do they have to have a contested case before the city council? No. In fact, it's impossible for the city council to hold a contested case because people both have the right to petition their government and go talk to my representative anytime I feel like, versus a contested case which cuts off the right to have that ex parte contact.
With respect, a hearing is not required to have an appeal, correct?
No.
Kila.
Right.
Decision is required.
A decision, a final order in a contested case, when it's an agency hearing is required by law. There has to be a hearing or a decision. I mean, you look at 9114.
A hearing or a decision.
You go back to 9114,
Right.
and it's, I mean, you can see in cases where a final decision and order in a contested case. So that's, as long as there's a final decision and order from a contested case, you're going to get your jurisdiction under 9114. So did that deal with your question?
No.
No. So I'm sorry. What is
Under
your question?
Kila, the Intermediate Court of Appeals said, we don't reach the issue because there was not a hearing.
There was not a hearing. There was not a
And the Supreme Court said,
right.
It's the functional equivalent because there was a decision on rights, duties, and privileges of one of the parties. Therefore, a hearing was required, and we're not going to, let you off just because you didn't have one.
Right, and that's the flip side of this is even when there's not been a contested case, if there should have been one,
Right.
that's enough to trigger. Now that's what a lot of us down, well maybe the ICA in Kila case, and a lot of us out in the bench or out in the bar haven't quite figured that out. The Hawaii Supreme Court reads the jurisdiction granted to circuit courts under 9114 very, very broadly. So there are cases when if you demand a contested case and are turned down, that's appealable, even though under the strict language of the statute, well, there hasn't been a contested case. How can there be then an appeal from a contested case? Trust me, that's the law. There is. That triggers it. You can demand one. There can not been a hearing, as in this case. There was a decision, and the Supreme Court said, well, that's enough. So, my rule of thumb that I have is, first of all, it's listed here sort of in the back of that discussion. Doesn't matter what the label is on your hearing or your administrative process. It is what it is. The Supreme Court's going to look at it probably very broadly. If it's required by rule, statute, or due process, it's going to qualify appeal. The court reads the jurisdiction under 9114 extremely broadly. I haven't quite figured out why that has to be so, but it's not my job to say so. I mean, that's what the rules that they've established are. In other jurisdictions, they sometimes treat these as questions of declaratory judgment. They read the administrative procedures rules very narrowly. Our court doesn't. Okay, would I prefer to live in a world where I could go to circuit court directly? Yeah, probably so, but that's not necessarily the rules are. And what I say, here's your strategy. When you're in doubt, demand a contested case. If granted and you lose on the merits, appeal. If denied a contested case, appeal. If the agency doesn't act on your request in time, appeal. So, it's a cautionary rule, I think, for lawyers. When in doubt, is there any danger in appealing under 9114? Probably not, right? Greg, do you want to add some into that?
No, I wanted to talk a little bit about the contested case hearing, and the key, I think the other thing you should talk about, though, either before or after I talk, is if it's not a hearing where you know what you did, you go through the Land Use Commission, they issue a decision and order, you had a contested case hearing, all that happened and you appeal, but in this situation when there wasn't a hearing, when all you get is a letter from an agency, from DPP, not allowing you to do something or something else, there's been a few cases on that, and that's an area because you don't know if you need to appeal that. You want to talk about those cases and that issue?
Let me sort of gather my thoughts while you keep going.
Sure. So in the real key to all this is the administrative appeal, the first appeal that you have to the circuit court, which is governed by Chapter 91 or 9114 and also by Hawaii Rule Civil Procedure 72. that both give you the 30 days and they talk about the procedure that the circuit court will do. And the most important thing, and I think all of us probably understand that, is the circuit court's not going to have a new trial. It's not going to receive any evidence. There's a little procedure in 91 that could allow the court to do that, but it's rarely done. So what they're really doing is just reviewing the record that was developed before the agency. So that's why it's critical that when you're going through the administrative process at the agency level, you are developing a record. You want to make sure you've gotten all your evidence in there, because the court's review is going to be limited to whatever the agency had to consider. And then they apply the standard of 9114, and the circuit court can only reverse on those 5 or 6 grounds that are in the statute. And so, it's critical that you think through what is the appellate court in the first case, the circuit court, and then the secondary review and tertiary review before the IC and Supreme Court. It is very limited, and just in terms of the procedure, once that HOPA appeal is filed at the circuit court, and I guess each jurisdiction can vary it a little bit, but here in Honolulu, in terms of when you have the argument on that. One of the strange things you get as you're ripening your case at the agency level is you will either have an agency that handles a contested case itself, whether it's like the Land Use Commission, for instance. They will schedule a contested case, and they will schedule hearings, and all the members that are present will sit there, listen to the evidence and everything. Other agencies, and Board of Land and Natural Resources, where's Bill? He's back there, is like that, where they will not sit and conduct a contested case. Usually they'll assign a hearings officer. So you have agencies that do kind of one or the other, and so for when you have these formal contested case hearings, either they'll be in front of the whole agency or the whole board, or they'll be done to a hearings officer who then will make findings and recommendation to the board to be adopted at a hearing, and then that's from what you will appeal from. So in either case, though, you need to be putting in all your evidence, because at the end of the day, under 9114, the circuit court is going to be looking at it saying, was the agency decision based on reliable and substantial evidence, reliable, probative, substantial evidence on the record? And if so, then there's this deferential standard in reviewing it that the circuit court applies and that the appellate courts apply as well, which is, and the reason for that has been explained by the Hawaii Supreme Court in the Kona Old case, that agencies have usually specialized abilities, and they are the ones who are hearing the witnesses and the evidence to begin with, and they have these special skills and areas, and so the courts are supposed to be deferential to that, and so it is a deferential standard of review.
Yeah, I'll pick that up where from Greg, take the baton from Greg and go back to what I think is the big open question. We know, I think in most cases, that the Hawaii Supreme Court will say you can go via administrative appeal under a 30 days time window under 9114. The question as a lawyer, again, that keeps me up night is, when do I have to go that route to the exclusion of others? And that's where you have to know, if you're dealing at all with agency processes, the primary jurisdiction and the exhaustion of administrative remedies questions that Greg has raised, because primary jurisdiction is when there's shared jurisdiction between circuit courts and agencies, and the court says, as a matter of judicial deference and comity, we're going to let the agency develop the factual record first before we hit the legal issues. And it's up to the court at that point, versus exhaustion, which is a mandatory doctrine that says the agencies have been delegated by statute, rule, or constitution the exclusive authority to deal with these things first. And therefore, if you raise these issues directly in circuit court with an original jurisdiction action, you're going to get thrown out for lack of jurisdiction. But it also means that if you have not filed your agency appeal within 30 days, you got some splaining to do to your insurance carrier at that point why you didn't. So when I say it keeps us up nights, it does. And then, of course, government lawyers here? Okay, well, there's a few. I mean, the government guys are on the ball, and if you file one, they're going to say you should have done the other. And if you did, so for instance, you file your 9114 appeal, they're going to say, well, you should have gone to circuit court. Or if you file your circuit court action, they're going to say you're too late. So you have to be very careful in walking that line. And but I think that's the big issue that's not been addressed by many of these court decisions that allow litigants to utilize the administrative process when they've elected to do so. And I'm not quite sure why they elect to do so, other than they're being very, very defensive about it, because, well, I've got 30 days, I might as well do it and take the issues of ripeness and exhaustion off the table. Because as a lawyer, I mean, I always want to be able to develop my own record, my own factual record again. Maybe it's because, as Greg mentioned, the rules of evidence basically don't apply, right? And in admin hearings, everything comes in. Has anybody ever seen a case where a court reversed on an evidentiary matter in an agency? I can't recall one, right? So the rule of thumb is everything comes in, and the hearings officer or the board will say, well, we'll weigh, give it the appropriate weight. So it's very tough to get reversed by a circuit court, to get a circuit court to reverse based on evidentiary issues, especially on mistakenly letting something in. Maybe that's why people go there. Me, I don't like 30-day statutes and limitations. They freak me out because I got to do it and I got to do it now. And you forget to make arguments when you do that. But anyway, beside that. So the question is, in what situations will you be deemed that you must use those type of the administrative process versus, say, something that looks like mandamus, right, or declaratory ruling under 632-1, saying that the agency should have done something, or the agency is violating the rules, and I want a declaratory action, or I want injunctive relief. My own sense, and it's nothing more than this, is that the Supreme Court, if asked those questions, would probably say, that there's no jurisdictional reason why you must use those, but would probably adopt some kind of rule of deference, saying we're going to defer to expert agencies on fact-finding questions within their scope of their knowledge, and then when it comes up to us through the administrative process and 9114, then the courts can kick in their knowledge of the law, right? Ultimately, the courts are the arbiters of what the law is. And there's a couple of cases, one of which has been decided by the Court of Appeals, and one which is now sitting in the Supreme Court awaiting decision on a cert application that you should pay attention to. The first one was an ICA decision. It's in your materials here, called Hokulele against City and County of Honolulu, a disclosure. We represented the party in that one. And in that case, they said that certain actions did not trigger. In that case, we did not follow we did not appeal to the circuit court under 9114 from a decision of the planning director here in Honolulu. And the Honolulu charter we said was very limited in what it required you to then take, what it delegated exclusive authority to the Zoning Board of Appeals to hear or to review those type of issues. And the ICA ultimately agreed with us and said, yes, this was a question where we had the option of going either to 9114 30-day appeal, and then, or what we did was we went under 632-1. We went straight to circuit court on a original jurisdiction declaratory judgment action, saying, essentially seeking a writ of mandamus. We invoked mandamus jurisdiction to say that the director could not do what he did, and the city said, wait a minute, you didn't exhaust administrative remedies. You did not go to the Zoning Board of Appeals. And the ICA said, no, we didn't have to. And the rule there, the way you figure that one out is go look at your authorizing charter, statute, rule, constitution, because that should tell you what the jurisdiction of your agency is. And if it's not within the agency jurisdiction to hear appeals from these type of matters that's in your case, then you don't have to go that way. Okay, so the other case up, the case it's called Kelberg against the County of Hawaii, Big Island, and that's up now. The Supreme Court accepted cert 6-7 weeks ago on a similar issue, and the question in that case is what is the obligations of agencies to give notice that something is appealable. Because our position, and we represent the petitioners in that case, our position was that if the county or the agency believes that a decision it has is appealable, it has an obligation under the Due Process Clause to tell the recipient that they think it's appealable and how long they have to appeal it and where they go. Now, in reaction to the Hokulele case, I've noticed that some agencies, particularly the City and County of Honolulu, when it makes land use decisions, has now appended to its letters, says, here's our decision in a particular case, your permit's granted, your permit's denied, whatever the decision is. You have 30 days in order to appeal this to the Zoning Board of Appeals. Here's the address, here's how much you got to send, and if you don't, you lose. Right? And that comports with what we say is the minimum requirements of due process. In the case of the Kelberg case, Big Island did not do that. It simply said nothing. It simply said, here's our decision. It was a decision that our position was that the landowner or the neighboring landowner should have no reason to know that was appealable, or at least the county would take the position that it's appealable. And therefore, that the county had some obligation to at least give them fair warning and notice. And so, court granted cert 6 weeks ago, roughly. So, no oral argument. I don't know what that means. It's such an easy case, one way or the other. Or either that or they want to get it in before Justice Sokoba retires, right? Not have to substitute. So we're not going to have oral arguments. We're just going to go. Move. But pay attention when that comes out, because I think it will, even though it's a land use case, it involves this sort of arcane issue of subdivisions. It will have effect on anybody who practices in any agency. Greg?
Well, I don't know. Recall what else we wanted to cover.
Well, we're getting close. I mean, we got about 5 minutes before we'll sort of open the floor to comments, questions, and whatnot. The other case I thought was interesting was another one. Where is it? December 19th. It was the other case that might have spurred Bethany to schedule this. Was in a case called Blake against the County of Kauai Planning Commission that's detailed in here, and there's a link to it in your materials. And it goes back to the question that I raised, that when do you have to go versus when can you go? And in this case, the Supreme Court seemed to say that you have to treat when you've got dual jurisdictions. I mean, normally it's a question between agency on one hand and court on the other. But in this case, it was a question, there was two agencies, a state agency and a federal, or a state agency and a county agency that might have to make decisions before the project could go forward. And the court seemed to treat each process separately. For instance, the state argued in that case that the case wasn't, or the county argued in that case that the issue was not ripe for review in circuit court under 9114 because the state agency might moot out the decision by not agreeing with the landowner or the applicant in that case. Therefore, the county's approvals might mean nothing, right? Because the state could ultimately kill the project using historic preservation issues. And the court said, no, that's not how we look at it. We're going to look at it. The agency made a final decision, and the court went back to the language in 9114. So there's a final decision in a contested case. It's appealable. I don't care if there's another agency out here that has some jurisdiction that as a practical matter might end up making the whole thing moot. You can appeal each one. And again, it left me scratching my head saying, well, what if I don't appeal? Can then I wait and then go back? Or if I just lost that one? And that's where our judgment, I think, kicks in a little bit. But when in doubt, appeal, right? When in doubt, appeal. Greg, do you have other thoughts in the few minutes before we throw this open?
No, why don't we take questions or...
We got, what, how much time we got, Bethany? I mean, what time? I don't know what time it is. Okay, yeah. Well, we got 10, 15 minutes for questions. Yes?
So I have a question about an agency hires a hearings officer. The hearings officer makes a decision, but it doesn't go back to the agency to look it over and make a final determination. Is there any deference given just because a hearing officer is heard in the administrative appeal as opposed to the agency?
Well, I think that the hearing officer steps into I guess it would depend on the statute or whatever sets up their role, but I think they step into the shoes of the agency. And while they tend not to be expert in the sense, because they're going to be retired lawyers or judges usually, not always retired, without any real particular expertise necessarily, but they are making the decision of the agency, and so it's granted that kind of deference. I haven't seen a case that says otherwise.
And from a practical standpoint, I haven't seen the court saying deferring more to decisions by agents made by the boards themselves versus a decision that's gone that one extra layer. I haven't sensed that in any case.
That issue was discussed in the Pila'a case. There was a major fine entered against Pila'a 400 LLC. It was affirmed at the ICA, and cert was taken, and the issue of the relationship between the board's decision, this was appeal, and the hearing officer was discussed. Whether that will be part of his decision or not, I can't say, but look for that. It's going to be interesting.
Other comments, thoughts? Yes.
Well, I wanted to comment, you said you lose sleep over these deadlines, and for those of us who do workers' compensation, my colleague Wayne Makita back there, 20 days you get to appeal.
Okay.
So you even get less sleep. And I also want to note that just this past week, we had argument before the Hawaii Supreme Court on an issue of appeal and the right to appeal. Wayne, in fact, was the main author of our amicus brief that we submitted on behalf of Hawaii Association for Justice. And it was a very good argument last week about the issue is a reduction of attorney's fees in a case in which, us practitioners, we have to submit at the end of the case a detailed breakdown of our fees, and the Disability Compensation Division has jurisdiction, and they can reduce your fees without explanation, and they have for many years, and we challenge that. And so, there was really some good questioning by the justices about whether or not attorney's fees are property right, and what the appellate notice and hearing and all of those rights. So I think it's going to be a good decision in favor of the attorneys, but something that you all ought to watch because it might have an impact on your practice.
Attorney's fees.
The Furukawa case is called Furukawa.
Where's Rebecca? I saw her earlier. Did you post up the briefs on that one, Rebecca, on your blog? Huh? Rebecca, did you post the briefs on that case on your blog?
McLaren?
Oh.
On the one?
Yeah.
Okay, yeah, see, and go dig around there and see what issues the court dealt with. And I imagine the recordings online already, the oral argument recording?
Yes.
And that also raises the same issue that Bill mentioned about when an agency has to explain what it does. Unlike, a lot of us who do arbitrations and other things, you have an arbitrator, you can ask for a reasoned decision or not. Sometimes courts give more explanation or not. But at the Pila'a 400 case, at oral arguments, there was a lot of discussions. Who knows what the decision will look like? But it's the same question here. How much of a reason or explanation does a board or agency have to give for what it does, or can it just do it? And that was the argument of I think the property owners in Pila'a 400 was that the board simply changed the hearing officer's recommendation without explaining why it did what it did, and that was on a fine, I think, Bill, right? And so there was some question, but there were a number of other issues in that case, so who knows on what they'll make their decision, I don't know. But as a general rule, agencies are supposed to make more detailed findings of fact and conclusions of law so that the reviewing court knows what they were thinking as they were evaluating the evidence and doing whatever they did.
Does the ICA give any particular priority to these appeals from agencies in terms of trying to get them decided sooner? Because, for example, if you get a permit granted, the developer wants to start spending millions of dollars. They can go ahead. The permit's not invalid just because there's an appeal. And but they have this problem of, well, what if I spend millions and then I get reversed?
My experience is no, that they're treated like other cases. Some cases of statutory priority, and if you do check your statute, For instance, certain aspects of eminent domain cases are immediately appealable, and they have docket preference by statute. The right to take, in other words, can the government take this property because it wants to resolve that issue before you get to valuation issues on eminent domain. Not FOIA, what do we call it at the state level? Freedom of Information, or UPA, chapter, the open records laws. Those have statutory preferences, and we've asked the Hawaii Supreme Court or the ICA in several cases to expedite it. What that means, I don't know. But my experience, Gary, is that no. In fact, we just argued a case at the Hawaii Supreme Court that was up on cert after, I think it was 4 or 5 years after briefing on a permit issue. So meanwhile, the landowner was kind of in limbo, and we've thought many times about how can we ask them to put this one up a little further on the docket, other than saying he's really suffering while this is happening, but then everybody thinks their litigants are suffering. So we ultimately did not, because we couldn't justify it, or couldn't say it was so extraordinary that it really stood out. But I don't know, maybe one of the judges or clerks could tell you that better than I could, but from my experience...
They won't.
Yeah, well, but you can ask. My experience is no, that it does not get any kind of preference, but that, again, I think there's no statutory preferences, but you can always ask depending on the circumstances of your case, because as you wait in limbo for the Court of Appeals or whomever to catch up, it's often tough on the litigants.
One, it's not really a related issue, but one that you need to be sensitive to is it an appeal that goes to the ICA? I think there's a few, statutorily, there's some agencies that there's a direct appeal to the Supreme Court, even after our cert. Is it even after the cert?
Yes, it used to be the Water Commission, right? There was a whole series of statutes out there that were set up under the old direct appeal to the Hawaii Supreme Court rule. And I guess who does that? Legislative Reference Bureau? Or somebody actually goes through and conforms all the statutes once the legislature adopted the cert review provision, and they missed one. So, for instance, there was a case where they still had in the Water Code the right of direct appeal to the Hawaii Supreme Court, and the court, I remember in this very short case, sort of said, yeah, but, and the legislature went back ultimately and fixed it. But there are, you do have to pay attention to your jurisdictional statutes, because, ultimately in that case it resulted in a easy decision by the Hawaii Supreme Court. You don't want to have to spend all your time and money litigating a case just to get a 2-line per curiam opinion that, yeah, you really could have gone to the ICA because you were smart enough to follow the statute. So worse yet, you goofed and didn't read the statute beforehand. So, but that's a very good point. There are some, I'm not sure there are any more, but there were for a while, because there's roughly 30-odd statutory schemes that had rights of direct appeal short of their own. And I think they cleaned them all up, but I'm not sure.
Just something else worth noting, we have, as appellate practitioners, we know you have a very short time to file the appeal, so that discussion with your client of what should we do if we get an adverse decision is better not made, right the day, okay, we now have 29 days to make a decision from now. But with the administrative appeal, you not only have to make that decision, but if there's potentially multiple routes to go, that's part of your discussion. Okay, what are the risks of us going here versus there? And 30 days is often a very short amount of time to make that decision. So as you're, it's one of those areas where it's good to know what the scheme would be going up and be able to advise your client accordingly that, hey, if this goes well, here's what this is going to look like. If this doesn't go well, we have a couple decisions to make, and we'll only have a short period to make them. So let's kind of, just so this isn't coming out of the blue when I get this decision from the agency 2 days before Christmas, which sometimes happens, and we now have, you're gone, and your client's gone for 3 weeks on top of Mount Kilimanjaro, and 2 days left to make your decision.
You had a question down there?
Sure. In cases where the agency should have had a contested case, or should have had a hearing, would a proceeding challenging the failure to have a hearing come up under 9114, or would it come up under 632-1?
The Hawaii Supreme Court has said you can. In fact, you can invoke circuit court's appellate jurisdiction under section 9114 when you've demanded a contested case and for whatever reason they either don't give you one or like the recent Kila case, don't get around to giving you one until after the decision. And I still, for the life of me, can't figure out how that worked in the case. And there must be something missing from the opinion because I don't know who argued that case, but that's awfully awkward to argue that, yes, Your Honor, this case isn't right because, we granted the permit and then granted them a contested case. Those kind of make you squirm when you hear those kind of arguments. So I just don't understand how that happened, but it's pretty clear from, I think, decisional law that the demand for contested case is reviewed. So in other words, what in other jurisdictions might be considered mandamus, right? Saying, I want a contested case, the agency says no, you then run to your trial court and get a writ of mandamus compelling them to give you the hearing that you say you're entitled by law, rule, or statute to get. Here in Hawaii, we can do it by the route of 9114. That's quite clear, I think, from the law that's set out in the cases here. Or if they simply don't act on it. For instance, they dawdle around and don't do anything. But again, it goes back to the question I keep posing is, do you have to go that route? Or can I then go invoke the mandamus power of the circuit court or the declaratory judgment power of the circuit court to do so? Or can I do both? Right? Me, I like to belt and suspenders, do both. Clients may not want or have the ability to pay for that, but until such time, that's the safest route is to bring, within 30 days, bring a complaint in circuit court invoking both 9114 jurisdiction as well as jurisdiction under your declaratory judgment and whatever the mandamus statute is, saying they have to give me one. That's it. Because the ICA's theory was, well, it says the circuit court can only review cases after a contested case has been held, and if they don't give you one, how can there be jurisdiction? The Supreme Court said no dice. It's an appropriate means of review.